Sheriff's Department spokesman Matt Lee sends word about an accident that occurred this morning at about 8:30 on Highway 153, just north of Gad Road Light. I guess it is on the hill there, and it involved three cars. One of them is a city police department cruiser, and well, he says that the accident involved two cars and one of our police cruisers. So I guess that he's referring to the city police department. Hang on, Carol. And so there were no injuries. The THP is on the scene investigating the crash, he says, since it involved a deputy's vehicle. A deputy's vehicle, as well as our traffic division. This is all the information I can give at this time. The evidence I saw was that one car had been pushed up on the bank, and its rear end completely smashed in. There were some people getting some effects out of the banged-in trunk, and I could not see any injuries. And Matt Lee, the PIO, the Public Information Officer for the Sheriff's Department, is saying that no one was injured. But I didn't have time really before coming in for the program to do anything, and I was asked not to park in the middle of the street with all the cruisers. It was not safe. Officer King said so. I scurried into the studio to meet with you, my listener. I do thank you for joining me. Now we have on the phone with us Carol Gaddy. She is in hiding. She's one of two people who are involved in a court case in Sequatchie County involving constitutional rights, property rights versus claims of authority, claims of jurisdiction by the municipal corporation of Dunlap, and the city, led by Mayor Dwayne Land, has been demanding permission to search the house under an inspection. It says it's just an inspection to look to see if it's a safe structure. But Carol Gaddy and her husband Thomas, they are in their late 70s, early 80s, are saying, no, we're not allowing that. We do not give consent to a search. The inspection is really a search. It's not just an inspection. It is a search, and searches are not allowed in the Constitution in Tennessee apart from probable cause or probable cause or a warrant. A warrant is obtained by probable cause, and the mayor does not have a warrant, and there is no probable cause to assume that any crime has been committed or there are any proceeds of a crime having been committed in that house. Now, the Gaddys have been out of the news for weeks on end now, and there's been silence on this case. I'm the only party reporting it in the Chattanooga area, and so in a way, it's our story. That is to say, it's your story, my listener's story, and it is a great conflict between the right of private property owners to maintain the sanctity of their castle versus needs and claims by administrative organizations. Such as cities, city governments, they're all municipal corporations. And in Dunlap, as we may hear from Carol Gaddy, whom we have on the line, in Dunlap, the rules say that all disputes under the ordinance have to be handled in city court. So the whole thing is in the wrong court to begin with. It's in Chancery Court now. I think it was under a couple of Chancery Court judges, or it was in Circuit Court, then in Chancery Court. And the rules say the legislature, which gave the charge to the city, says all disputes about ordinances have to be under the city court. So that there's a misstep there. And now, Carol, thanks for joining us. Now, what I want to ask you about is a letter of which I've received a copy from your son Kelly by email a couple days ago from an engineer. What does this letter say?
Oh, you mean the report, the inspection that we ordered from outside the city of Dunlap?
Yes, ma'am. From Fields Engineering
inspection?
Yes, ma'am. What does that letter say? What's that about?
Okay. What it states quickly is we contacted a company over the internet, our son Kelly did, who my first question to him was, did he know anyone in Dunlap? Had he had any previous business with anyone, any connections in Dunlap? And he said no. And so we hired him to do a construction engineering report on our home. And he says, the representative Fields Engineering, Mr. Fields did it himself, performed a structural integrity inspection of the above referenced dwelling on July 24th. The dwelling was constructed in approximately 1900, and according to the current owner, had been allowed to deteriorate to a point the structural integrity could come into question. Now, when we bought this property, he's talking like 20 years ago. I gave him the history on this house, and it was being used. It was in very, very bad condition, but it was being used as a beer bar in the community. So it was a very rundown structure when we bought it and the acre of land there on the creek. Since that time, the dwelling has been remodeled, expanded, etc., but is not complete. In other words, I told him that we had been under a restraining order by the city of Dunlap since February of 2015. He says, during our inspection, we examined the following extensively: foundation, flooring support, interior, attic, roof support. Subsequent to a thorough examination of the entire dwelling, we found nothing that was not 100% structurally sound. It is also our opinion that once the remodeling project is complete, the dwelling will be a tremendous asset to the community. And then the man took 33 photos from the floor system. We've got photos of the floor structure, the roof structure, the new wiring, the interior photos, and like I said, this is our last ditch effort to disprove Attorney Greer and Mayor Land's lie, their outlandish lie. Now, I will mention this: we have had to. Our only offensive move, we have been defensively defending our home and our property for 2.5 years in court. And our only offensive move was to list these 12 men's names and filed a federal lawsuit against them under a U.S. code. It's called Title 18, Conspiracy Against Rights. And it's pretty explicit. It's good law. It's old law for our country that most of the lawyers and the judges are ignoring that law. It states if two or more persons conspire to injure, oppress, threaten, or intimidate any inhabitant of any state, territory, or district in the free exercise or enjoyment of any right or privilege secured to him by the Constitution or laws of the United States, or because of having so exercised the same, they shall be fined not more than $10,000 or imprisoned not more than 10 years or both. And
all right, so let's get back.
So many people in Tennessee.
All right, what's happened to this case, Carol? What is the status of that federal suit? Did you file that in Chattanooga?
Of the federal suit, yes, we did. We filed
what's
that
the status
in
of that?
January
How's that being?
year.
How's that case being prosecuted if you're not there to do it? You are in hiding, Carol Gaddy, with your husband Thomas.
Well, the way we're handling things is our son Kelly. The legal process, David, is they file on us through the court case, and then we file back through the court case. They have filed that case. Here's what is so
the city of Dunlap
to know about our federal case, and I call it our federal case. There is a lot of work that goes into filing a federal case, especially against 12 people. 3 of these people judges, 3 of these people lawyers, and the others politicians in Dunlap, in our area, in the 12th Judicial District. We had to get someone to serve summons and personally serve these on each of these individual people. I mean, the money plus the expense of filing that action in federal court. And a week ago, in other words, the proper for federal is there's 3 divisions.
Well, listen, Carol, let me just hang on, Carol.
Tennessee, which is at Chattanooga.
Listen, Carol, I want to back off and let's not discuss this federal case much more. My time is limited. I want to find out about this engineering letter. Let me ask you this: have you sent copies of this to Mayor Land, to City Attorney Stephen Green? Have they seen this letter? Is this part of the conversation?
We've got a filing right now that's going. I know it's radio and you don't have a lot of time, but you told the folks when this civil case against us started. It started simply, in other words, a person is supposed to have a true basis to file a civil suit against someone else. And this language of anybody that we've reached out to. We reached out to the FBI in Knoxville. Everybody we have reached out.
Carol, come on back.
The State Attorney General's office, a lawyer there named Heather Ross, fought us. These guys, when we filed the federal suit, got 12 lawyers, a dozen lawyers to defend them. And what's so offensive about this to me, and I hope to many others, is all of these lawyers are being paid by tax dollars. And the one that filed the motion to dismiss, because they're the defendants in that case, was a lady with the State Attorney General's office named Heather Ross. Well, while that was going on, we also had filed 2 cases in appellate court.
Well, Carol.
One specifically to get rid of this Judge Thomas Graham. He's been in there 20 years. He came from as a municipal judge, and I've given a lot of thought to this. We need the people of Tennessee to call their state legislature and start prepare and get another new law. We've already got one law across the state based on our case that states that a municipality must prove that they have any jurisdiction over a person's property when the person says they do not have jurisdiction.
Well, let's bring that up, Carol.
Proved on Dunlap that they've never annexed us.
All right, let's just stop for a second about the federal case. I want to focus on the city of Dunlap, and you are right. There is a new statute, and that says that when a doubt is raised about a municipal corporation's jurisdiction, that there has to be a showing to the state that an annexation was true, that it did happen. And you're saying part of your defense is that you're not in the city of Dunlap, even though Coops Creek, the curve there, and your house nestled in that bit of shrubbery there is very close to the town hall. You're saying that it was not truly annexed in the 1970s. That's one of your arguments, right?
Yes, that is correct.
And now the city's having to prove
file folder that proves it searches legal descriptions. Everybody knows that ownership of property is in the Register of Deeds. It runs with your meets and bounds, which is your title ties to your survey, in other words. And the Coops Creek was used for 150 years. They call it the meander line that surveyors use. And because that's a natural geographical line that never changes. And so we proved that previous annexations, when the city began to grow, all went north and west. And our property lies south and east of the city, even though you're right.
Well, okay.
We can, if we had a powerful slingshot, we can land a rock over there near in front of City Hall from where our property is. But the fact is, the way the city grew and the way that they expanded, and here's your strange thing, that all their annexations, we've got copies of those from the registrar's office, and they were accompanied by surveys. Well, we fast forward up to when they say they annexed us. They just came in court and said, well, yes, to Judge Stewart, we annexed them in 1972. Well, we went through the equalization board, local equalization board. The city coughed up 2 documents only. And this is after we had a letter from the Secretary of State's office approving that over all the amendments to their charter, over all the years, that they had never changed their legal description on their city charter.
This is David Tulis. We're talking with Carol Gaddy. Carol Gaddy is in a fight with the city of Dunlap. And Carol, hold on just a second. We're talking with Carol Gaddy, and I want to get back to the question, Carol, about this engineering letter. Is this letter seems to have the authority? It is an independent engineer review of your house, the disputed house in Dunlap, that says it is a house that's safe. It is no danger to the public. A thorough inspection was made, and and we found nothing. The engineer says that was not 100% structurally sound. How can this letter?
Exactly.
Let me ask you a question, Carol. Hang on.
That letter, that structural engineering. Actually, I have a contractor in Georgia that suggested that we get a constructional engineering. He said, I don't know what it costs. He said, I think they're kind of pricey, kind of expensive. But he said, you need to do that. He said, because that overrides any local municipality. Now, this man's talking about even a city like the city of Atlanta. He said, you submit that. Well, Here's where
Well,
we're submitting it.
The question is,
we
how
are
does that get
submitting
into the stream of litigation?
But here's another kicker. Based on the new law that cities have to prove up, we thought we would have a little rest break here and could sit back and say, well, now let's see the city prove up, because they would not prove it in court, and a judge would not make them prove it in court. They had an ordinance, and they had a boundary description only. Well, City Attorney Greer decided to pull another fast and loose with the court, and I've already addressed that in the filings. It's in the court record by, hiring a surveyor to get this. Now, this is laughable. This is so funny. He tried to trump up, Attorney Greer, a piece of proof once we raised the issue of, you should have had a survey. You should have had some sign of public meetings or something in 72. See, we didn't live in the city in 72. We didn't move there till 97. So this surveyor takes their boundary description and a felt tip pen and draws out their boundary description on a sheet of paper on a map. So I responded back that any good real estate broker can read a boundary description and take a felt tip pen and outline the, on a county map. And so that
Carol, my time is limited. Carol,
at trumping up some proof.
Carol, listen, you need to listen to me just for a second, and answer my question. All right, what will is this document please be concise with your answer, and try to, I need to ask you a couple more things here before my time runs out. Okay. What has this document been submitted to the court? Is there a way to end the impasse with the judge? You're under a finding of contempt, and the moment they find you, you're under arrest. Now, can there be a way that this document could smooth the way so that when you make your appearance, you're brought immediately to the judge, Judge Graham, in Chancery Court, and everything is there some way of ending the impasse where you can get back into your house and not live in hiding now as you have been for several months? Carol Gaddy.
Well, it's a powerful document, David, but the reason I'm doubting it would have even that effect, even though it's the truth, and the truth is supposed to dispel the lie, these men have a vendetta. They have this clannish bully, thing about them that they just. This is the part that's hard for people to believe, that these men want to hurt you, that they would desire, with deliberate intent, to prove their point of. You remember when it all started? I told you face to face. Mayor Dwayne Land said, "I will hurt you." He wants to hurt us. Oh, one correction, David. You said we were our late 70s, early 80s. We're late 60s, early 70s.
Okay, thank you. Sorry. I knew that was wrong the moment I said it.
Making us 10 years older, this lawsuit and all of them. But let me tell you the kicker with the new law. We were very happy, and we said, oh, good. Now, this ought to end it. This ought to turn things around. Well, what's happening on that is it's being twisted. See, our state judicial system. Now, I don't mean to say we don't have good judges. I totally believe, and I have seen one, good judges in the state of Tennessee. The problem is the judicial system across Tennessee is very dysfunctional. Innocent people are being persecuted, railroaded. I mean, there are so many people that are using the court to perpetuate fraud and theft and false accusation that it has corrupted our entire court system across the state. But the administrative judge, believe it or not, now I've got to learn administrative law, sent us pages that we were going to be required to abide by every rule and every technicality. And even though the law says the municipality must prove, there's an administrative judge in Nashville called Rachel Waterhouse that we are now supposed to coming up on a hearing, and Mr. Greer has filed to her. She sent to us. He has filed once, and I have filed once into that administrative case. And I have a filing that'll be going out of Chattanooga today, because Mr. Greer is requesting that our hearing on this administrative matter for both sides to show their proofs will take place at the Justice Center in Dunlap. And the Justice Center is where Thomas and I have been so abused. Thomas was physically attacked by a Squatch County deputy and hurt very badly. And, well, we've both been attacked. We've both been in the jail. And, David, here's what we want the listeners to know.
Yeah, Carol, you have half a second. Go ahead.
If the County Jail gets their hands on me and my husband again, we will not make it out of there alive.
This is David Tulis talking with Carol Gaddy, and she is under a contempt finding by a judge, and she says that if they are arrested, they will not escape Sequatchie County Jail alive. This is David Tulis, Nooga Radio. I do thank you for a moment of your time, and now I've got some important messages. David Tulis.
In-depth traffic, news, and information. Mornings on Nooga Radio, AM 1240 and 92.7 FM.
A $20 oil change. Right now at Precision Tune Auto Care, a standard $20 oil change at Precision Tune Auto Care, Hickston Pike, Gun Barrel Road, Highway 58 next to Dunkin' Donuts. A $20 oil change. Precision Tune Auto Care. Go now.
Essential oils are an overlooked benefit. They're a remedy for allergies, sinuses, headaches, and sleep problems. Aches and pains? Let me help you live a better life. Hi, Loretta Lynn here. It's a free consult. Call me today. Look, I'll even give you a free bottle of essential oil. 423-605-4719. Loretta Lynn's Essential Oil.